Hey everyone, Josh Denbo, consumer advocate, consumer attorney. I sue banks, represent people, sue car dealerships. My expertise is in defending secured debt, which includes mortgages. So there's a lot of information out there regarding mortgages and separation of the note and the mortgage and all these hooky-dooky defenses that make absolutely no sense. Somebody posted something that didn't make any sense on the internet, on my YouTube channel, which you're watching on a previous video, and I kind of jumped on it kind of hard. Felt kind of bad, sort of rude, saying, look, that doesn't make any sense. I'll eventually do a video on Articles 3 and 9 and explain how mortgages actually work in the secondary market. Instead of getting mad, the user wrote back and said, that would be great, which impressed me. It made me feel kind of small because I hadn't been polite. Look, here's how the situation works. Uniform Commercial Code is a state statute that's known as a uniform state statute because it's been adopted by every state. It may be Louisiana adopted something different. I don't remember, but whatever. 49 out of the 50, and I think all 50 of them. And it governs commercial transactions. It governs a lot of different things. Article 3 is negotiable instruments. Article 9 is the security for negotiable instruments. Article 3, negotiable instruments, is a note. Article 9 is the mortgage. So when people say, I paid my mortgage, it really doesn't mean anything because you never did pay your mortgage. You paid your note that was secured by your mortgage that was attached to your deed, and that if you didn't pay, the bank went to court or to the clerk's office, depending on your state, and said, hey, you know what? I have the right to enforce the note. I own the mortgage. I want to change the name on the deed from the borrower's name to my name. That's what a foreclosure is. And if you heard me very carefully, I said the right to enforce the note, that's language from Article 3, and I own the mortgage, that's language from Article 9. I can't explain to you all of Articles 3 and 9. It's a massive, massive body of law that is slightly nuanced, different in every state. But I can tell you this. When a bank or a mortgage servicer or an investor or your cousin Charlie or anybody buys a mortgage loan, they're buying the note and the mortgage. And the idea that the note and the mortgage can be separated and is separated by securitization, which is the commingling, is putting a whole bunch of mortgage loans into a big financial product and then selling bits of investment pieces of it. That's securitization. The idea that securitizing the mortgage loan breaks the mortgage loan so that it's unenforceable is a pile of BS, nonsense, whatever you want to call it. It's crap. It's not how the system works. So a note and a mortgage are basically always together. Is it possible that one entity will own the mortgage and another entity possess and have the right to enforce the note, and that they are both still permissible to be enforced as a single instrument? Yes. Yes. It happens all the time. So if you remember, Article 3 is if you possess the note, if you have a right to enforce the note, same thing basically. So the company or the entity that is going to file the foreclosure complaint has to have the right to enforce the note, has to have legal possession of the note, either in their own name or the contract with a holding company to hold the note for their benefit. That's still their possession. That company looking to enforce the note might be a mortgage servicer. And the investor contract with that mortgage servicer might not transfer ownership of the mortgage to the servicer for the purpose of foreclosure because they don't need to. They don't need to. They don't need to. So is the note in the possession of one company and the mortgage owned by another? Yes. Is it still enforceable? Yes. Why? Because there's a contract between the two. The mortgage servicer who has taken possession of the note and has the right to enforce files the foreclosure complaint or processes the foreclosure action and says, hey, look, I possess a note, I have a right to enforce it, and I represent the owner of the mortgage. That's totally legitimate. So there are defenses to foreclosure. Most of them have to do with origination fraud. Most of them have to do with mortgage servicing mistakes and errors, which includes failing to properly log a modification agreement. A new servicer comes in and misses payments. Payments are taken applied to the wrong mortgage. The escrows, the taxes are improperly assessed, and default is declared even though the taxes are current. There's all kinds of different ways that a mortgage servicer can screw up the servicing and create real powerful arguments in opposition to foreclosure. But arguing that fundamentally the note and the mortgage are separated and can't be enforced because of some misunderstanding by the entire $3 gazillion industry as to how notes and mortgages work as a matter of law, it never works because it's always nonsense. It's always nonsense. So if you're going to go and do your own research, dangerous thing to do, okay? Because I have expertise in this. There's other people who have expertise in this. We've been to school for way more time than I want to admit or remember. I've been litigating in courts for 25 years. I've dealt with 3,000 of these things. I've been in the federal courts, the state Supreme Court, the appellate division. I don't know how many trials I've had, hundreds of trials, thousands of cases. You can't catch up to me. It's like me going to do internet research and become a doctor to treat myself for a broken bone. How? I can't. I don't even know that my arm's broken. I need somebody to tell me who knows what they're doing. It's like, running a restaurant. I could probably figure some parts of it out, but if someone said to me, hey, look, would you like to run this restaurant? So I have to do the ordering. I have to do the employee management. I have to do the cooking. I have to oversee it. I don't know how to do that. I'm a smart guy, but there's an expertise, there's a knowledge base that you learn by being part of the industry that you can't catch up on. Everybody looks on the internet and says, or not everybody, a lot of people look to the internet and come to the conclusion that they know things because it makes sense when they read it. Stop doing that when it comes to mortgages and your house and protecting your investments. Reach out to someone who knows what they're talking about. I've done other videos how the consumer protection industry works. You're not going to pay anybody for a consult who knows what they're doing. That's just not how the industry works. All right? Look, splitting the note and mortgage, not a defense. Article 3 governs enforcement of the note. Article 9 governs who gets to enforce, who gets to own the mortgage and the benefits of the mortgage. I know I have just barely scratched the surface. I know people are going to have questions. Just put them in the comments. I'll answer them. But the bottom line is, anybody who posts a video or comment in some blog post saying, oh, your note and mortgage has been separated, it doesn't count. They're full of baloney. Go, instead of communicating with them or spending time reading their nonsense, do something more useful like rearranging your sock drawer or building a pig from a kit or anything else. All right? Be well, everybody. I got your back.